Hello, I'm Bob Henderson. Jan Friedlund and I are partners in RJH Consulting, working with small law firms. We are also two of the founders of the Elder Law College. We wish to welcome you all to the first of our many webinars. It is my pleasure today to introduce our partner, Scott Solkoff, who will be our speaker today. Scott is a board-certified elder law attorney and operates Solkoff Legal PA, one of the leading elder law practices in the country. He has the Martindale AV rating and is a fellow of ACTEC, the American College of Trust and Estate Counsel. Scott is the founder of a statewide multidisciplinary elder care conference, now in its 14th year. With his father, he wrote the definitive book on elder law practice, West's Florida Elder Law. Scott has led various state and national bar and elder care organizations and has served on numerous government panels dealing with the subject. One of Scott's greatest loves is teaching. He has helped many attorneys begin and better their elder law practices. Today, Scott will talk about adding elder law to your existing practice. If you have questions for Scott, you should chat them using the green chat icon at the top of the questions page, then click on the host button at the bottom of the page and send your question. Scott?
Thank you. If you have any technical problems, folks, you can also text in any problems that you're having. We'll try to help you. Very pleased to be speaking with you today, and I'm going to give you a brief overview of what we're talking about and then get right into it. The idea here is to talk about how to transition into an elder law practice, and I'm assuming, therefore, that some of you have dabbled in elder law, have some knowledge of elder law, are all practicing lawyers. We know that you do a variety of different practice areas, but all of you have indicated some interest in transitioning your practice into elder law or adding an elder law component to your existing firm. The problem that most folks have in getting there is, how do I do that? How do I get up and running as quickly as possible and do a great job at what I'm doing while balancing my life? So that's what we're going to talk about today. And I'm going to start off by giving you an overview of where I'm going to go with it. We're going to talk about the three requirements of how to get up and running, the three needs for success, the difference between being ready and being an expert, practical versus substantive knowledge, and then we'll talk briefly about Elder Law College and how we provide a solution as well. So the objective here is to add an elder law practice quickly, effectively, and profitably, to transition to a rewarding special needs and elder law practice as quickly as possible, while still having an income coming in as you're doing this, doing whatever practice areas you're already engaged in, but in doing so, gaining expert class knowledge so that you can go out there and accurately represent yourself soon as being a thought leader in this field. And there's a way to do that. It doesn't come instantly, but it can come quickly if you go about it the right way. A big part of this is your own confidence. I can tell you without a doubt, most folks feel that transitioning into a whole new practice area, it's rather a daunting proposition. But the fact is if you have a system thought through ahead of time about how you're going to go about doing it, and you can outline your path, you're going to feel more in control and be able to manage that experience. And I can personally tell you from my own experience of helping other lawyers who had zero experience in elder law that you can do this. You can become an elder law attorney. You can master the practice relatively quickly if you have a system and stick to it. You have to have the willpower and a system. So we're going to talk about that system that I've used with others to train that has worked for them in a way where we've systematized that now. So the way I see it, there are three requirements for you to have success in this practice area. I just want to pause for a moment, though, before I get into substantive knowledge and practical knowledge and having an expert on call. Before I get into that, I want to pause for a moment and explain that when I graduated law school, I wanted to take the highest paying job I could get. Now, mind you, when I went to law school, and this may sound familiar to you, I was very idealistic. I had my own thoughts of what being a lawyer was, and I wanted to fight the great constitutional battles of the day. I wanted to help people. I wanted to make money, but I wanted to help people, and I wanted to accomplish some meaning in my career. Having said that, when I graduated law school and I looked at my bottom line with my student loans and everything on the competitiveness of it all, I just took the highest paying job I could get. I lost my way for a little bit. I went into commercial litigation. I happened to have been with a wonderful law firm with smart people that I still respect and learned from. But it wasn't for me. I had one human being client the entire time I was there. I was making more money than I ever thought I would right out of law school. Had a beautiful office overlooking Tampa Bay, watching the cruise ships come in and out. But I had very little job satisfaction, especially when I looked around and I saw the other attorneys ahead of me who had been with that firm for 3, 4, 5, 6 years or longer, and what their lives looked like. The fact that they were getting to work when it was dark out and leaving when it was dark out. And these were folks who had families. I didn't have a family yet. But I knew enough to realize that this wasn't what I wanted for myself. Meanwhile, I knew a guy, my father, who was practicing elder law. This was a new discipline. There was no national academy. There was no state bar associations. It was a new practice area. And it didn't seem very exciting to me. It sounded rather dull. But I took my 1 week vacation in my father's law office. And that first day, he had 6 families come in rapid succession with the most core human problems and issues you could ever imagine. And he helped them, and they gave him hugs and a check. And I was blown away. And I had not always respected my father, but had renewed respect for him. He had one secretary and her daughter, no computers. He was the town lawyer, loved what he was doing, wasn't in it for the money, and I would say that most of the folks that founded the field of elder law were real idealists. But meanwhile, I was starting my family. I needed to make money. So I took what I learned from my father, having a great teacher, a great leg up in this field, and learned how to make a business out of it, make it financially viable so that I could earn money. And I became successful at that. I went to the first foundational meeting of the National Academy of Elder Law Attorneys when I was still in college because my father was doing that work. And then when I became working in elder law, having worked with my dad, I started meeting with other lawyers that were very knowledgeable, that knew more about the business of elder law than admittedly did my father. I learned how to charge. I learned how to manage books. I learned about how to create systems, and I read a book called The E-Myth that changed my life. If you haven't read it, I highly commend it. And I every year since then had meetings with the most successful elder law practices in the country, and still to this day meet annually with a small group of lawyers where we share a lot of information, and their firm administrators, and we share a lot of information together. I hired Bob Henderson, who introduced me. He runs RGH Consulting, which is a small law firm and medium law firm consulting firm nationally, and does great work. Has probably worked with more small law firms than any other consulting firm. And he also was able to give me a new path that helped me reach more life-work balance. So I share all this with you now so that you understand how I got to the point that I'm now going to share with you. Not everybody has a father who is in the practice and wrote the book and helped found the field. I did, and I never take it for granted. But I have made it my mission, as he made it his, to help other lawyers. I love doing it. So we co-authored this 1,000-page book. It's now in its 14th edition. And Elder Law College is another way for me to train other lawyers. So you have to understand the law, the substantive knowledge. all the different practice areas. And I'm going to go through them with you today so that you can have a sense of what I need to learn first and what I can put off to later. Then, let me get back. So you have substantive knowledge first that you want to be able to get down. And then there's the practical knowledge of being able to run the law firm and be able to know what to charge, how to speak about your practice, how to create your workflow systems, your document checklists, to have quality controls and job descriptions and make sure that everybody knows what they're doing from phone call to the office until completion of a case. All of that matters tremendously, not only to your end game, your work product, but also to your own quality of life. Then beyond that, there's the having an expert on call. As I said, I had that in my father. I was very fortunate. I had in my office for the first 3 years at least, an expert who I could talk to anytime and be able to have answers. I could never have learned how to practice elder law by going to seminars or reading a book, or if I did learn, it would have taken me years. And some lawyers have that path. That's the only path. But I learned from an expert, and that's, as I'm going to explain to you, the only way to go. Rather than taking 3 years as an existing lawyer to learn how to do it, you gain the knowledge that you have to learn through books, seminars, but you have an expert on call. You can't let the perfect be the enemy of the good. You want to be able to do what you do well enough to launch your practice. Have that expert in the wings so that you know that you can always deliver the service that you need to deliver and get it done right, be able to solve the client's problems. But don't feel that you have to know every aspect of the practice area before you open your doors. It's impossible to have that type of expectation, although I can tell you that many do, and it keeps people from success. There is a shortcut to one's expertise, but no instant solution. So you can go to seminars, you can read books. It'll take years to master the practice. We're going to talk about shortcuts and ways to get there quickly while maintaining your existing revenue base. No instant solution. You have to be ready and committed, and be ready and capable with your expert in the wings or your experts in the wings. They might be your substantive expert. You might have a different expert who's your business consultant, or sometimes they can be wrapped in one person or one group. You want to be able to confidently represent your clients. So when that client comes in, you feel good and comfortable. When they present their problem to you, it's something you were already prepared for. And most importantly, something that you can convey to them your confidence in, so that they know they've come to the right place, that you can help them. And even though you may not know every single aspect of what to do as you're starting out, you'll know enough to be able to make that initial consultation meaningful and rewarding to the client, where they feel better when they leave and they're willing to hire you and write that check. And then you'll have enough knowledge to form that base, that primary knowledge to form that base, and have your experts on call to move forward with it. So there are first stage practice area categories in elder law and second stage practice area categories. That's the way we'll break it up today. This is the way I'd like you to think about it, so to make it not so daunting, to make this a manageable process. Elder law is a big field. It overlaps many other fields, family law, estate planning, and other areas of civil practice. But the main difference, I should say, between elder law and estate planning, the way I'd like to frame it, is an estate planning lawyer is primarily concerned with post-mortem planning, what happens after I die, whereas the elder law attorney has a different focus, and that is on the lifetime needs of our clients, and then what happens after we die. So while the elder law attorney must be very facile in estate planning and end-of-life issues, more importantly, the elder law attorney has to be equipped to deal with the lifetime needs of the clients, such as dealing with incapacity, or access to health care, or making sure I don't get wiped out and lose all of my savings towards the cost of long-term care. That's a very big difference in focus, even though there's a lot of overlap. So incapacity planning and solutions forms a very big part of the elder law practice. And I would say that is tops in terms of a first stage practice area. And what I mean by incapacity planning is, fully, for my traditional elder law clients, fully 85% have come to me because there's already some type of dementia diagnosis in the family. It's such a big part of what we do. And so even for clients who come and they're well and fine, we're talking about planning for incapacity. Our document sets that we use for powers of attorney, for example, or advanced healthcare directives are very different than traditional power of attorney forms and healthcare advanced directive forms. And not only does this solve a real problem that people have about dealing with incapacity in a safe way, but it also sets me apart. When I'm meeting with my client and they come to me, by the way, often from their estate planning lawyer, they come to me with their documents in hand and say, I already have a power of attorney. I've already done that. I already have a living will. I've already done that. Well, we're able to say that, hey, look, it's a wonderful thing that you have those documents. And the lawyer that did those documents did them right for the reason that they were retained. But we're going to talk about this in a very different way. And when we lay out what we're doing with our powers of attorney and what we're doing with our healthcare advanced decision making, right away we're laying out our value proposition to the client, and they get it. So we're doing incapacity planning in a very different way than would a traditional estate planning practice. Incapacity planning and solutions also have to do with asset protection and public benefits planning, special drafting considerations in trusts, because you're going to be able to use the inter vivos or lifetime provisions of trusts in innovative ways that will help that client deal with not only long-term care planning issues that are set to come down the pike, but also incapacity issues in a much more real and imminent way than a traditional trust agreement. Then we have post-mortem estate planning issues. So if you've done wills and trusts to any substantial degree, that's a big core knowledge base to become an elder law attorney. You have to understand wills and trusts. We use wills and trusts all the time, even though we're not focusing primarily on what happens after death. We're focusing on lifetime needs. After death needs are a big part of what we're doing, informed, though, first by what we're doing in our lifetime planning. So we use wills and trusts, we use testamentary trusts, we use surviving spouse trusts, we use special needs trusts, and those are the kinds of issues that you have to have as your first stage practice area categories when you're looking at your knowledge base. What do I have to know to open up my doors as an elder law attorney? We would start with incapacity planning and solutions, which is your powers of attorney, your advanced healthcare directives, and your inter vivos trust language, and sometimes some other tools. Post-mortem estate planning, what happens after my clients die with their wills and trusts tied into my lifetime planning. And then third, the lifetime planning for long-term care. And this is, I've saved and saved and saved for my retirement. I have X number of dollars. It's all I have. I don't have an excess amount of income coming in. I have to be careful with my money. And these are folks, mind you, when we're talking about long-term care planning and asset protection, these are not millionaires. These are working-class folks who have saved anywhere from $100,000 to maybe $2 million. And when you look at the cost of care and what it's going to do to their finances, most folks can't afford to pay for the cost of long-term care for too long without getting wiped out financially or hit very, very, very hard. And so they stand to lose their lifetime of savings. So the idea of long-term care planning in an elder law context is to create pots of money where the client does not have to exhaust all of their own before getting, for example, public benefits. So I want to be able to access Medicaid. I want to be able to access VA benefits, perhaps, and other tools that will create other pots of money to finance my long-term care, have my own dollars set aside to pay for the things that those government benefits won't pay for. Well, that's a very big part of my elder law practice and most elder law attorneys. That's a core discipline, a core part, a first stage practice area knowledge. Under lifetime planning for long-term care are a panoply of other terms that you've heard of and know about, and and that list would include Medicare, Parts A, B, C, and D. What are those? How do they work for my clients? Accountable care organizations from the new Affordable Care Act, how that works. Medicare rehab dollars and how my clients can use those smartly. These are not difficult concepts to master, by the way, but they're things that you need to know, be able to open your door. Then you're going to want to know about Medicaid home and community-based services, Medicaid nursing home benefits, VA benefits, including aid and attendance and dollar programs that provide reimbursements to people to cover the cost of home care, assisted living, or nursing home care at the same or higher quality than people get if they were private pay. And so we want to know, what are the strategies that work in my state? How can I move countable assets to non-countable assets? Because the way the government has the system set up is I have to be broke before I can get Medicaid. But if I have to be broke and then get Medicaid, I have nothing left to pay for everything Medicaid doesn't cover. So the difference between the client who comes to you and helps protect their assets in a legal and ethical way and the client who spends everything is they have money to buy more care, and more care means quality of life. And you can demonstrate this to the client when you're sitting down with them. You can show them dollars, and the value proposition is so tangible that they understand exactly what you're going to be able to do for them and the value of your work. We're talking about typically tens or more commonly hundreds of thousands of dollars of benefit to these clients. So our substantive knowledge, first stage, is incapacity planning and solutions, post-mortem estate planning, wills and trusts, lifetime planning for long-term care, which is predominantly based on using Medicare smartly, Medicaid smartly, and sometimes VA benefits. After those are mastered, along the way, you'll be pulling in other knowledge bases that you'll need to know. For example, estate and trust administration. This doesn't differ much from a traditional estate planning practice where we're doing probates and trust administration, except for the fact that we have to tie this in often to public benefits. And when there are public benefits involved, there are different estate administration ramifications that you'll learn to take into consideration. We also need to know about guardianship and conservatorship. So even though our job is often to avoid guardianship and conservatorships for our clients by planning ahead for incapacity, oftentimes by the time they come to you, they can't sign documents. How do you move forward with asset protection planning or the client's goals to enhance their quality of life if they themselves can't participate? Well, sometimes guardianship is necessary, and so this is something that you'll eventually want to learn, but you don't need to learn right away, because if you need to, you can farm that out. You have to have your first stage practice categories all good to go, right? If you got your first stage categories, you're there. But if you can also do guardianship later on, then that's something you don't have to farm out. You can keep that in and control the process of those cases for your clients. Special needs trusts, I also consider a second stage practice area, although there is some first stage crossover. Every elder law attorney needs to know about special needs trusts, period. Having said that, most elder law attorneys don't hold themselves out to be specialists in special needs trusts. They use them for limited purposes within their traditional asset protection planning for their elder law clients. But a second stage practice area is being able to take that special needs trust knowledge and kick it up a notch for people of all different ages so that you're doing public benefits planning and work for people of all different ages who have disabilities. This is a very big value added to your practice and something that has really enhanced my ability to help my clients and created a new revenue source, diversifying my practice considerably. This is facility resident rights, it should read, not facility resident trusts. The idea here is to understand that your clients who are in nursing homes or assisted living facilities, well, first off, for most of them, it's their first time doing this. They don't know a lot about it. You're going to know a lot about it. I'm going to tell you how to get that knowledge. A second stage practice area category would be learning how to enforce your client's facility resident rights. so that when that nursing home tries to transfer them because of a behavioral issue or moves them to a different room, maybe treats them differently, discriminates against them in terms of admission because of a Medicaid application, any of those things, you got to know what the law is in order to be able to help them. I consider the second stage not first stage because it's not essential, but it's pretty helpful and ultimately something that you're going to want to add to your knowledge base. So we consider that a second stage. That comes later after mastering your first stage practice categories. Your expert on call, though, will know all about that. And then another second stage practice area category is dealing with insurance and health plans so that you can counsel your client and guide them through how to use their Medicare smartly, their Medicare supplement. What's the difference between a Medicare supplement and Medicare and a Medicare Part C, Medicare Advantage plan, or the new ACOs? How does that all work in for your client? Those are things that you don't have to master to be an elder law attorney, but they're things that you want to be able to add in after your first stage of knowledge. So your practical knowledge of how to actually use all of the substantive knowledge is your implementation. So you've learned the law, you know and understand Medicare and Medicaid and special needs trusts and estate planning tools. You've got your core knowledge and you have your expert on call. How do you deliver the services? How do you get the phone to ring? How do you get the phone to keep ringing? How do you make sure that your practice is going to be successful in terms of actually successful representations so that you have great results? Not good. You don't want to be an average elder law attorney. You want to be a great elder law attorney. You want to be proud of your results and do incredible work for your clients, and you can do it. And by the way, it feels awesome, and you make money doing it. So the idea is to be able to run your practice the smart way by putting it all together, understanding the difference for getting the phone to ring. This is your marketing. And this may not be far different from the marketing you do now, especially if you're a small law firm or a sole practitioner. The ways that you get your business now may not be too different. You identify your market. Okay? If I'm an employment lawyer, I'm looking at the size of businesses that I want to contact, and I'm looking at HR people. Right? If I'm an elder law attorney, I've got two markets. I've got a wholesale market and a retail market. My wholesale market are my referral sources. These are the social workers, discharge planners at hospitals, social workers at social service agencies, social workers at doctors' offices and medical practices. These would be other attorneys, which are my lead referral source. These would be facility administrators. These are your wholesale marketing sources. So a part of being successful in starting your elder law practice is, again, you identify your substantive knowledge areas that you need to go through. You set up your plan. You get your expert on call. Then you develop your marketing plan. Who am I going to contact? And what's my plan for keeping my contact with those people regular and making sure that they see me as a competent authority in this practice area? And being able to give back to those referral sources. So, for example, you can get a lot of business from assisted living facilities. You got to show the assisted living facility not only that you're going to do a great job for that client, but that it's in their best interest to refer that client to you. Well, recently I toured an assisted living facility, and I made sure that I told them a client fact pattern of a client who comes to me, which is not uncommon. They have $300,000, say, teachers who saved their money, and they're afraid of spending $4,000 a month for the assisted living facility. They're concerned that it's going to really set them back, especially because they know that nursing homes are going to be at least double that amount, and they've got to be able to prepare and save. Well, if we can shelter assets and show the client the different pots of money and what Medicaid will pay for and what perhaps VA benefits will pay for, and how to use their own pot of money smartly, and then show them what the ALF includes and map it all out, they might feel better about the financial aspects of moving into that assisted living facility. And so you're doing the client a great service by laying it out for them but you've also helped that assisted living facility, incidentally, and you should let them know that. Let them know that your work happens to help what they do also. And so whenever you're meeting with these wholesale contacts, being able to show them that, hey, not only do I do a great job, I really care about my clients, and here's our systems, etc., but this will help you too. Retail marketing in elder law is also divided into two categories: retail marketing to the elders themselves and retail marketing to the adult children of the elders. More and more elders are doing practice planning on their own. They're moving forward with this planning on their own because there's more knowledge and education out there. But oftentimes, by the time a problem is identified, their adult children are involved, and they're asking questions in the community to find out what they can do and who they should go to. So you want to be able to reach both of those audiences and let them know what you do, what your solutions are, and why your solutions work and are effective and valuable. And again, it's a system. So like anything else, when you decide, I'm going to do this elder law practice, and you're mapping out your plan of attack, you know your substantive knowledge that you have to get, you create your marketing plan, you're getting the phone to ring plan, and you're getting the phone to keep ringing plan. By that I simply mean your systems in place to make things work in the office, your happy staff, your staff who knows exactly what's expected of them, who have measurable criteria for determining success in their position, your workflow system, so that from the moment the phone rings until the close of the case, and by the way, the close of the case is going to be very carefully defined in your representation agreement. All of that is going to be laid out. Everybody knows what they're doing, feels confident in what they're doing. You have systems in place, it's organized, and that creates happy staff, happy lawyer, happy owner, happy client. And the clients see this reality. They see this when they're in your office, and as soon as they step in, we talk about the first moments of impression. We want them to understand and see that we are organized, that we have a solution, that we care, and that they really did come to the right place. And you're going to be able to do that as well. So this also might involve client appreciation programs and letting people know that you're happy to speak to their groups when that client comes in and happens to be the president of the sisterhood. You want to be able to speak at their meetings. So it's about setting up a plan, being prepared for those marketing opportunities, and running your practice the right way. Understanding personnel issues, workflow issues, job descriptions, finances. I mean, my gosh, how do you charge for all of your work? That in and of itself is a science. And I have it's taken me years, and it's still an evolution. I still learn, and I'll tell you that I had one person in particular who was able to sit down with me, and we worked the numbers and really figured out a pricing system that works for a client so that they feel the value, it's demonstrable at that first meeting, and I'm making money. So that it works. Pricing is a big part of any practice, and in elder law, it's no different. So you have to have all of that down. Your expert on call. Well, here's my theory. I had a great teacher. Well, more than one, but my greatest teacher was my father. As I say, not everybody has a father who's an elder law attorney, so they can't just go to dad and learn how to practice. I did, in large part. And then I added other experts who knew how to run the business of the practice. When I went to my dad's practice, there were no computers. There was one staff person and her daughter who worked part-time. My father is a great lawyer. Doesn't practice any longer, but is a great lawyer. Really, truly cared about his clients. But making money was not really important to him. It became important to me. And sometimes I feel guilty when I see how much money I make. But I put my clients first. I know that I've got the right priorities. But the only way I was able to learn all of that, my ethics, my substantive practice area, my business, was an apprenticeship. Law schools were not always law schools. Lawyers learned how to be lawyers through an apprenticeship. And I still think it's the only way to really, really, really learn. And when you think about what you do right now as a lawyer, you're probably doing that area of law because it was what you were trained in at first. You learned it from other lawyers. If you can learn elder law from another lawyer who's not afraid to teach you, who's not holding back because you're going to open up next door, or who's not holding back because you're working in the firm and they want you in a particular pigeonhole, who actually wants to teach you unfettered, you will learn quickly, especially with a system in place. It remains the only method of mastering an existing discipline. I happen to know some very wonderful books. It's a big part of my practice is writing that book. We have to edit it every year. And as proud as I am of the book, it doesn't teach you how to be a lawyer alone. You have to have somebody walking you through it. So practicality also dictates that you get up and running quickly, not after years of apprenticeship. I know you don't have time to do the Ben Franklin model and work for 6 years as you learn how to lawyer. So you need to learn quickly. And having that system set up means finding an expert, and you may find one in your community. But if you find a system, and that's what we've put together at Elder Law College, you're probably going to get up and running a lot quicker, or you will get up and running a lot quicker. So we have apprenticeship, we have the getting up and running quickly, and you want to be secure in your practice. You want to feel good and comfortable and confident taking in those clients, and that when they leave, they know that they had a good lawyer, and you feel good about it because you have your primary practice areas down, you have your first stage elder law practice areas down, and you have your expert who you can call and bring in because you have a system, you have an arrangement already set up with that lawyer or lawyers, so that you know that you're going to be taken care of. Your clients are going to be okay with whatever practice area or whatever cases you decide to take. You want to keep those experts. I still consult with Bob and other experts who have helped my practice. As I said, I meet every year with a group of lawyers who have practices throughout the country, and we share information and learn from each other. It's imperative to me. And it's a big motivator for me to have this call with you today to try and share information that I've learned. And it really, again, it's just about creating a reliable system. So I hope that this has been helpful to you in terms of creating a framework by which you can transition into elder law. I'm going to stop talking now for a moment, and then I'll be able to answer questions. But I want to turn it over first to Bob Henderson with RGH Consulting and Elder Law College.
While Scott is reading through some of your questions, I'll take this opportunity to invite you to the Elder Law College's 3-day intensive training in Orlando in mid-November. The training is, as the logo indicates, a 360-degree program. It not only provides you with substantive knowledge of the law, but how to market this practice area and how to price your services and how to manage the cases in your firm. You will also be provided with Scott's library of proprietary documents. Then, having completed the training, you have an opportunity to become a member of the college with online tutorials, Scott's articles as he publishes them, and ongoing support as you develop this lucrative practice area. If you would like to learn more, just type your name in the chat box and we will follow up with you. No obligation, of course. Our class sizes are intentionally small, so if you're interested, let us know. Now, I'll turn the webinar back over to Scott, who will respond to your questions. Thanks.
Okay, thanks, Jen. So some of your questions, I'm not going to be able to get to them all, but I'm going to do the best I can. I know you have other things to do today too, but I think some of these questions will help others that didn't ask them as well. So let me pull some of these up here. Okay.
Scott, while you're doing that, do you want to go to the next slide?
Sure. Let's see here. Okay.
The next slide gives, no.
Okay. So
there we go.
I've got I have my chat screen on, folks. I'm looking at your questions. So, and you got some good ones. So, okay. So one question is, is there is it too late? Essentially, it's a longer question, but essentially, is it too late to become an elder law attorney? There are a lot of elder law attorneys. Well, I can tell you this, that when I first started practicing, there were a lot less. When my father started, when I went to the first NALA conference, I think it was 1986. I was in college. Okay, so that gives you my age. There were 15 people at that NALA meeting. Now there are 6,000 members. So you might say, well, gee, this is already a saturated field. I don't think so at all. I can tell you that my office is in Southeast Florida, which is a pretty big retirement area. And there's a lot of competition. There are a lot of good elder law attorneys here in the area, but there's plenty of work. And I can honestly tell you, although I really don't want everybody opening up next door to me, I can honestly tell you that there's room for good elder law attorneys, probably in every market. The baby boomers are just coming of age, and so the need is tremendous. Healthcare is becoming a big deal. I spoke last night to the Broward County Bar Association. My office is in Palm Beach County, but about the Affordable Care Act and how that's going to affect our clients and our special needs practices especially. This is a very, very growing field of practice. I don't have all the statistics in front of me, but you can pull them up about the aging population in America and the lack of preparation for long-term care. Long-term care insurance has barely penetrated the market. They say they have a 1% market penetration. Long-term care insurance is not enough. The elder law attorney is able to organize their clients' assets and prevent them from loss at the greatest risk. So I think there's plenty of room to do elder law, especially for those who are highly motivated. That's my answer to that question. I see more questions coming in, and feel free to continue to ask questions. I love these. How much do you charge? So is this a client or an attorney? So how much do I charge? Well, we have different ways of representing clients, as you will, and you should have. I'm very productized, and the way I teach at Elder Law College, and the way I teach other lawyers, is to create products. Our lead product at my firm is a package of services that we call it Family Asset Protection Planning. You can probably come up with better names. But it is a system that deals with estate planning, long-term care planning, estate recovery prevention. We handle the application processes with the government, and we guide them through quality of care issues, what to say, what not to say, kind of the social work aspect of what we do. And we charge a flat fee ranging anywhere from $9,000 to $30,000 for the work. That's a lot of money. That's expensive planning. But by the time they hear those numbers, they've already seen the numbers of what it costs to pay for care without our planning. $9,000 a month for a nursing home is a lot of money. Our fee pays for itself in just several months of coverage. So we're able to show the value proposition. We're able to charge a fair fee. Our fee is all-inclusive. We don't charge by the hour. Some of my colleagues do. I can tell you how to charge by the hour if you prefer it. But I'm also going to tell you why I don't think you should. So that's how we do our charging. Here's a good question. How do I get paid from people who are on Medicaid? I get that question a lot at different programs. The answer is this. My average client are working class folks who save money. They have money, but they don't have enough money to pay for their cost of care. They've saved and saved. So let's say I have a client with $500,000, which would be about an average client for me in my neck of the woods that comes to me for asset protection work. Okay? Well, $500,000, if the cost of care is $100,000 a year, they may not make it. They may outlive those assets, and the surviving spouse is going to have a very hard time for the rest of his or her life, let alone anything that they wanted to keep in the family for whatever reason, and for them to get the care that they need above and beyond what the government's going to pay for. So those are folks who have money, who need your help, who are willing to pay for your help because you bring a tremendous value to them. Remember that Medicaid in every state pays for nursing home care. And even though nobody wants to go to a nursing home, they're all filled up. And they're filled up with all the people that said they're never going to a nursing home, sadly. And we could talk a lot about that and why and how to avoid nursing homes, but the bottom line is most people will need them. You can put it off. You can't avoid it, I shouldn't say. So for those folks, they have the money to pay you, and while some people will balk at the price and have a problem with it, your business model will be such that you will have plenty of work to handle. Here's another question. Give me a moment to read this one. Okay, so the question essentially is this work legal and ethical? I'm just going to give that, should be a short answer. Yes. Of course it's legal and ethical, but I can understand the question. There was a law passed in, I forget the year now, but it was a big deal when I was doing it, 96, I think. 96. It was a law passed by Congress that said that people cannot try to protect their assets and then apply for Medicaid. In other words, not purposely impoverish themselves and then apply for Medicaid. Well, the National Academy of Elder Law Attorneys and other groups got involved and were very upset by this, of course, and branded this ingeniously as the Granny Goes to Jail law. And these were people who were doing legal things that the government wanted to make illegal to do the planning. So the National Academy of Elder Law Attorneys and other groups, including the AARP, who was very helpful on that, were able to get a law change. Guess what they did? They said, okay, Granny won't go to jail. So they changed the law and said anybody who advises them on how to protect assets to qualify for Medicaid has committed a crime. Well, that bothered the National Academy even more, as you might imagine, and the American Bar Association, and the Attorney General at the time, who was Janet Reno. She wrote a letter to Speaker Gingrich and said that this is a blatantly unconstitutional law that violates people's right to counsel and right to contract, and she refuses to enforce the law. And a federal court found the law to be unconstitutional. So from a legal standpoint, we feel we're on very solid ground. And by the way, just as an aside, I have to share this. I, for years, talked about this Granny Goes to Jail law, and really don't much anymore. And I talked with pride about Janet Reno's letter and what she did and how she stood up for lawyers and people's constitutional rights to do their legal planning. And I was giving that speech one day, and she was in the audience. And I held up her letter, and she said, "I am so glad I wrote that letter. That was one of the neatest experiences of my speaking career." So anyway, it's absolutely legal and, in my opinion, ethical. These are working class people who saved and saved and saved their money, and they certainly have the right to avail themselves of legal strategies that allow them to move things around and take countable assets and render them non-countable. I could go on and on and on about that. I'll stop because I have more questions. I want to get at least one more question in. And that, well, this is the softball. Thank you for asking this question. This must be somebody who I know. But it says, how does Elder Law College make this work? Well, the bottom line is that, look, you can everything that we've talked about today, you can do on your own. I marvel at my colleagues who hung a shingle in John Doe Elder Law Attorney, and they figured it out. They bought the book. They went to the seminars. They're smart. They studied hard. They listened at the seminars. They eventually worked through it. They just took cases and figured it out and made it happen. And I love that. I mean, that's perfectly possible. But I can tell you that It took years for anybody that I know to get it done right, to be able to do it safely, effectively, to be able to make money at it. And if you have an apprenticeship program where you can work with a lawyer who's really willing to open up everything to you, not hold back, has no other agenda than teaching you, then you will learn. I started doing this work accidentally when lawyers would call and say, Scott, would you be willing to help us start an elder law practice in our firm? And I did it. I put together a program. I put together binders and PowerPoints and went to their offices with all my discs and did programs for them. And eventually, Bob and Jan found out about this. As I said, Bob and Jan are law office consultants, so I've worked with clients of theirs and successfully started elder law practices for them. So they got to see that, and we decided that there was an organized way of doing this, and that's how Elder Law College began. So we do have a way of packaging this together, making it easier for you so that without any other agenda, it's to get you up and running as quickly as possible to transition into an elder law practice. The bottom line is this: it's all you, and it's your motivation, and I think that part of it is confidence, knowing that you can do this, that you can put it together, that you can keep doing what you're doing while still making that elder law practice work, and you can scale into it. But it comes down to that system that I talked about, and that's mapping it out for yourself. You can use this PowerPoint as a guide because you have to know, what are the substantive knowledge areas first, what are the practical knowledge areas second, and so forth. Be able to put it all together and make it work for yourself. If you have a written plan, I create the Scott Solkoff plan. It's your own plan, your plan about how you're going to make your life different, how you're going to make it all work, life balance, work balance, and be successful at it. But that's what Elder Law College is about. I want to thank you very much for joining us today. It's a privilege to be able to speak with you. And as Jan said, if you're interested, just go ahead and chat your name and your contact information or email address, and they'll get in touch with you. Again, thank you very much, and have a great rest of your day.
Okay, this is Bob again, and we wish to thank you also for attending our webinar. And as both Jan and Scott said, if you're interested in our seminar, it's going to be held November 19 through 22 in Orlando, or you want further information, simply type your name in the chat box and we'll get back to you right away.